I'm Leslie Stein, Director of the Government Law Center at Albany Law School, and I would like to welcome you to the fourth and final program of the 2022 Warren M. Anderson series. The mission of the Government Law Center is to help state and local governments better serve their communities through nonpartisan legal research and analysis by bringing together a diverse and inclusive group of lawyers, students, scholars, and community partners. We prepare students for careers as skilled and leading attorneys in public service. We advance Albany Law School's unique connection to government and inform nationwide conversations on government and the law. This year marks the 30th anniversary of the Anderson series, and today we have a distinguished panel of speakers on the important and emerging topic of Texas Law SB.8 and copycat laws designed to avoid judicial review. Our moderator today will be Vincent Bonventre, the Robert L. Jackson Distinguished Professor of Law at Albany Law School, and our presenters will include Professor Richard Briffault of Columbia Law School, Professor and Associate Dean David Noll of Rutgers Law School, and Attorney Justin Harrison of the New York Civil Liberties Union. I encourage you to read their impressive bios in the CLE materials provided to you. Before we begin, I would like to thank our series sponsors, family members in memory of Sharon P. O'Connor, Albany Law School Class of '79, and the law firm of Whiteman, Osterman, and Hanna. Finally, just to let you know, a code word will be announced during the program, which will be necessary in order to obtain CLE credit. I will now turn the program over to Professor Bonventre.
Hey, thank you so much, Judge, and thank you for inviting me and this distinguished panel. Having just endured reading this piece of Texas legislation, I was struck at how it goes on and on and on. And obviously, there were those who counseled the Texas legislature to try to preclude any possible challenge to this law. And I'd like to start out by asking each of our panelists if they can give some opening remarks on their reactions, their reflections, initial ones to this Texas law. Let me start off with Professor Richard Brafalt. Richard?
Yes, thanks. Yeah, I mean, I think you've captured it. It is very cleverly designed to prevent pre-enforcement judicial review. It is obviously, it both has a substantive component, which I guess the Supreme Court will soon make almost unnecessary if we're to believe the Dobbs leak. But it's really designed, it's the so-called fetal heartbeat law, which basically says that once a so-called fetal heartbeat is detectable, an abortion is prohibited. So it probably on the substance violates Roe and Casey as they now stand. But of course, the whole point of the law and the mechanism it develops and perfects is to prevent that review from any kind of pre-enforcement review from happening, and to operate as kind of interorum because of the nature of the mechanism it creates, the lawsuit mechanism it creates for private enforcement actions, for what Justice Sotomayor calls bounty hunting, or what David in his article calls vigilantism. Makes it almost impossible for any abortion provider or somebody who would assist an abortion provider, which could include the Uber driver taking a woman to an abortion clinic, makes it basically impossible for them to defend themselves successfully if they're ever sued. So it's a pretty impressive piece of work. I don't know if you want me to go further now, or this is an opening round for everyone to give a little bit.
Yeah, let's hear from David, who you just referenced with his vigilantism piece. So David, you want to give us some opening reflections?
Yeah, sure. Thanks so much. And it's great to be here with the panel, although I wish we had a more auspicious occasion for gathering. So I think the challenge with this law, and the thing that a lot of commentary on the law has attempted to grapple with, is really understanding what's new about SB.8 as compared to more familiar forms of private enforcement, such as lawsuits to enforce the Sherman Act, or claims under the Civil Rights Act of 1964. My co-author, John Michaels at UCLA, and I have been, we started working on this before SB8 captured headlines, because some attorneys in Tennessee reached out to us for advice about a Tennessee bathroom law that used an SB8-like enforcement mechanism to be enforced. And so we have been, we've been struggling, or we've been working to try and understand how to think about these laws, both as a legal matter and then their larger political significance. And as Richard kindly noted, sort of one of our main interventions is to identify them as a form of legal vigilantism. And I want to stress the legal, because when we think about vigilantism in general, you think about people acting outside the law to undertake a law enforcement function. And we think that as important as the evading judicial review aspect of this statute is, and to be clear, that's, it's very important, and it's allowed Texas to really get ahead of the Supreme Court's opinion in Dobbs and do something that the anti-abortion movement hasn't been able to do for many decades. But as important as the manipulation of judicial review, we think, is the way that this new breed of laws epitomized by SB8 are sort of encouraging foot soldiers in the conservative political movement to undertake the work of really sort of pushing policy through citizen monitoring, citizen enforcement. Some people more pejoratively call these snitching provisions. But there's really sort of an effort to deputize private parties in the political work of the law. And troublingly for us, that aligns with more familiar forms of vigilantism, like marching on polling places with assault weapons, or various other examples that we're all familiar with of how people have tried to influence political discourse through force.
Well, thank you, David. So, Justin?
Sure. I mean, to piggyback right on top of David's remarks about vigilantism, my first thoughts when I saw this law were essentially that this is going to create an interesting race to the bottom, as other jurisdictions come up with similarly retaliatory schemes that, as David said, deputize non-state actors to enforce the enforce the rights, or enforce the punitive measures that that the governments can't, and that, that the executive branch can't, and that the state courts can't. We'll have to see what happens in California with their bounty law on guns. But yeah, this is just going to create a cascade of retaliatory measures in various states. The other thing that I wanted to do, I'm going to put a link in the chat. You've probably already seen this, but it's a link to a 2018 law review article called "The Writ of Erasure Fallacy," which seems to be kind of one of the pillars of this idea, one of the origins of where bills like this came from. And it's really just a stunning paper to read. It's an instruction manual on how to avoid federal judicial review. So if you have the time, and if you haven't already seen the piece, I encourage you to take a look at it.
Well, thank you. But can any piece of state legislation really prevent judicial review? Because even in Justice Gorsuch's majority opinion in the latest whole women's health case, he did allow an action to go forward against the Attorney General, right? The Attorney General of Texas. So
not
is it really possible for a state? Go ahead, Richard. I'm sorry.
Not against the Attorney General. He allowed it to go ahead.
Oh, I'm sorry. You're right. I'm sorry. Yeah.
he allowed it to go ahead against the heads of the various state medical societies.
Yes.
And the Texas
License.
Supreme Court, the Fifth Circuit and the Texas Supreme Court undid that. Because the majority in the U.S. Supreme Court interpreted other provisions of the federal health code, this Texas health code, excuse me, to permit, to basically say if there was a finding of a violation against an abortion provider under the Heartbeat Act, that would result in the possible imposition of penalties, loss of a license, for example, under the medical board, the nursing board, et cetera. And so therefore there was a basis for suing them. When the case went back to the Fifth Circuit, instead of immediately sending it back to the district court, which is where it had started, the Circuit kicked it over to the Texas Supreme Court, certified to them for an interpretation of of the Texas code. And the Texas Supreme Court unanimously said those officials have no role in enforcing the heartbeat law. They do other things, but they don't enforce it. So that case disappeared. I mean, in effect, of course, if somebody brings a takes advantage of the law and brings a bounty hunting lawsuit against an abortion provider or against the Uber driver who drives the person to the abortion, and that person is able to defend by challenging can defend at that point and challenge the constitutionality of the law. Of course, under that law, there's universal venue anywhere in Texas, so you can pick the judge you want. There is no fees or costs for a successful defendant, and you'd have to win. So basically, the question is anybody willing to take the risk? I guess apparently one doctor in Texas has indicated he has broken the law once, as if to invite a lawsuit. But the real question is, yes, of course, it is right. Ultimately, you can get review of an enforcement action. But what you can't get, as these cases are showing us, effectively, is at least federal pre-enforcement review. There is pending litigation in the state of Texas, but part of the problem is figuring out who to sue. The litigants in Texas managed to have sued Texas Right to Life, and they are challenging their being sued, and that's working its way through the Texas state system. But it is a clever thing because it's hard to figure out who you're going to sue in advance. If nobody in state government can actually bring an enforcement action.
Yeah, of course, Richard's absolutely right. The last few opinions I read were Roberts's dissent and Sotomayor's dissent, and they were saying, well, why can't the Attorney General be sued since related provisions in Texas gave him authority to enforce these provisions. Now, David, you were nodding your head quite vigorously. Did you have something you wanted to add?
No, I mean, just to first of all, pardon the honking car horn if you can hear that. Someone's bashed a car outside my home office window. But the justiciability issues here are quite complex, and I think as the case has gone up through the Texas courts and up to the U.S. Supreme Court, folks have tended to oversimplify the extent to which the reviewability of the law under existing precedent is a settled question. You have Ex parte Young, you have a handful of cases applying the Young exception to state sovereign immunity. If you dive into your federal courts casebook, I think you'll find that there's not really any case which is squarely on point. And so the amenability of the statute to pre-enforcement judicial review in federal courts is, I think it was something of an open question when the case went up to the Supreme Court. I think an important part or sort of an important feature of litigation over the law is the extent to which the Fifth Circuit has actively intervened in district court proceedings. I'm not a Fifth Circuit practitioner, but the Fifth Circuit on an appeal from Justin is on an appeal from one of the district court's orders denying an immunity defense, took what I thought was the pretty extraordinary step halting all district court proceedings, which I've spent a lot of time in district courts in New York, which is not something I remember a court of appeals ever doing in New York. So there's a sense in which there are a lot of different actors and a lot of different institutions that have contributed to the current state of affairs. And I think it's, as Richard noted, I think the Texas Supreme Court, the Fifth Circuit, sort of all of these different institutions that are involved with SB8 and passing on the law have played some causal role in the success of the statute with success with appropriate qualifiers.
David, I'm surprised that you could possibly say that Ex parte Young doesn't well define a doctrine, because Justice Gorsuch was so certain that it was very clear, although I heard him at oral arguments once say that the Constitution's provisions were brilliantly specific. And I actually asked my students about that, about whether the provisions are brilliantly specific with every single case that we discuss in constitutional law. Go ahead, Justin.
No, I was just going to add, before coming up to New York, I was the legal director of the ACLU of Louisiana. And so I did a fair amount of litigating in the Fifth Circuit. And, anytime we had a case where there was any doubt, we used to apply what we liked to call the Fifth Circuit handicap. They've always had an independent streak. I think the Fifth Circuit is certainly emboldened by recent appointments from the Trump administration and the current composition of the Supreme Court. So, one of the things that impact litigation organizations are doing, and I'm sorry if this, isn't as encouraging as some folks might want to hear, is just kind of waiting to see what the other circuit courts do with bounty style laws like this. I mean, the Chief Justice's dissent in Whole Women's Health made it pretty clear that he didn't like the idea of state statutes that could completely avoid federal judicial review. Justice Sotomayor in her dissent, made it pretty clear that there's now a roadmap for states to pass laws like this targeting other fundamental constitutional rights. So yeah, I mean, a lot of, how we respond to this in terms of what we do on the ground is going to be dictated, I think, by the rest of, the Article 3 court's reactions to, to laws like this as they pop up in other states.
Right. I know this legislation is all about private enforcement, but I mean, it's legislation. It can't be entirely private, right? I mean, there's plenty of state action to go around in this, right? It's a law that's enacted by the Texas legislature. So doesn't that give us some hope that this can be challenged more than Texas thinks? Go ahead, Justin.
Well, yeah, and I was just going to say, when you file a federal lawsuit, the first question you always have to ask is, how can the court provide relief? You have to, who can I sue? And if you're looking for equitable relief, the real question is, who does the court have the power to enjoin? Who enforces this law? And when these laws pass in other states, there's going to be, different language. Somebody at the state level, there's got to be some government official who is charged with putting the pen to paper at some point in the enforcement process. And we're just going to find out, who that person is. We're going to have to find out who that person is and, hope the court agrees.
Why isn't it enough that a state legislature, that a government legislature passed this law to give it state action, which would make it amenable to federal judicial review? Why isn't that enough? David, Richard?
Well, again, picking up on David's point about the some of the uncertainties of Ex parte Young, but still the argument is, and let's see how Justin is right and David is also right, we're not going to really know until these play out some more, is that the states have sovereign immunity under the 11th Amendment. So you can't sue the state. I mean, and that even applies to suits in state court. challenging, asserting the federal unconstitutionality of the state statute. So you can't sue the state itself. But under Ex parte Young, you can sue the responsible state officials. But who is that exactly? That's the cleverness of the law. You probably can't sue the legislature, which are the responsible officials. They're the ones who passed it and the governor who signed it, because that's in some sense suing the state, and they're not actually involved in enforcement. The clever thing is, and I think this is David's point in his article, is that there's no government role at all in the enforcement. This isn't, as with most private rights of action, are ancillary to a government enforcement designed to get more private, that the private attorneys general are complementing and supplementing the public attorney general. Here, the statute says over and over again, and the Texas Supreme Court relies on this, there's no public role at all in enforcing this. So except, and this is really where some of the division was in the court, and you could actually see, once again, with Chief Justice Roberts' opinion, the divide between the conservatives and the very conservatives, is what about the attorney general's a possibility, also the judicial clerks. In some ways, the most interesting line there was Roberts saying you can't sue the judges. You couldn't bring a class action against all the judges of the Texas court system, which would kind of sound in Shelley versus Kramer. But you could bring a class action against all the clerks in the Texas judicial system to bar them from docketing the cases. The court rejected that 5-4, but there were 4, including the Chief Justice, who said you could bring that class action. So, but that was, I think, the effort to find some public point. That's your point, is where does the public come in? And those of us who remember Shelley versus Kramer have taught it in property, the courts are state action. And so the judgment, I think if a judgment was ever issued, that would be state action. There is state, unless Shelley versus Kramer is overturned, and with the current Supreme Court, who knows? But for now, at least, a judicial judgment would be state action. And for 4 of the 9, docketing would be state action. But it's unclear where the state action is in the enforcement process.
What about any legal vigilante who brings a cause of action? Isn't that individual acting under color of the state authority? Is that not the case, David?
Yeah,
Go ahead.
There's a couple of different senses in which state action is relevant to the ability to bring a pre-enforcement suit. So first, you have 14th Amendment state action, where in order to be governed by the Due Process Clause of the 14th Amendment, you need state action. So when people talk about Shelley versus Kramer, right, they tend to talk about state action in that sense, because the argument in Shelley was that this is just a private covenant. And so the 14th Amendment's prohibition of racial discrimination doesn't apply to what landowners do with their land. There's also a requirement in Section 1983, which folks like Justin used to litigate constitutional issues in federal court, which creates a private right of action for actors creates a private right of action that runs against actors who act under color of law. And so typically a Section 1983 plaintiff is looking for someone like that. And that's where, right, that's one legal doctrine that SB8 exploits, because typically, right, color of law doctrine is its own section of the federal court's casebook. But generally, that's where you want to see a state official or someone acting in league with a state official. And what SB8 is doing in saying that it shall not be enforced by any official of the state or local DAs and so on and so forth is trying to cleave off the private actors so that there's not an actor acting under color of law for Section 1983 purposes. And then there's a whole other body of doctrine that talks about whether the threat of an enforcement proceeding, which cases tend to assume will be brought by a public actor, is sufficiently imminent to create a justiciable controversy in federal court. And as Justin pointed out, Jonathan Mitchell's article, which forms the template for SB8 in some ways, tries to take advantage of all of these doctrines to essentially create obstacle after obstacle for federal courts exercising federal jurisdiction in a pre-enforcement challenge to the law.
And then, of course, there's that other obstacle created by Justice Alito's majority opinion in the Clapper case, where in order for there to be justiciability, right, standing, rightness, it had to be, what was the term he used? It had to be practical certainty that someone was going to be injured. It couldn't just be that there was a good probability. It had to be some certainty, and that also is a way that helps to immunize this law. Isn't that the case?
Yeah, generally in all but First Amendment cases,
Yeah.
There has to be an imminent risk of enforcement to the specific person bringing the suit. The courts are a little more relaxed in 1A cases just because you can sue to vindicate the rights of others, and you can bring a pre-enforcement challenge alleging merely a chilling effect, on behalf of people who might not be willing to sue, who might be too timid, or who might be too at risk to sue. But yeah, the other thing that I just wanted to interject was if I could just reach back to finding the person who's charged with enforcing the law. Different state laws define those people differently too. For example, when I was litigating in Louisiana, and we didn't do any business in the state courts of Louisiana, my entire practice was federal courts. State court, we'd get laughed out of the room. The Louisiana Attorney General under the Louisiana Constitution does not actually have the authority to enforce the law. So every time we sued, as part of our group of defendants, the state attorney general, the district court would always throw out the AG. And, to conform the pleadings to the right parties, eventually the court would say, all right, well, how about we just issue an injunction against all 63 district attorneys in Louisiana. And there, you have the relief you were looking for. Amend your complaint to reflect that. We'll leave the AG out of this. We'll leave the governor out of this. And you can get the relief you want in the form of an injunction that applies to the top law enforcement officials in each parish in Louisiana. Parish being a county for anybody who's unfamiliar with the way Louisiana is structured.
Now, in criminal law, of course, if somebody is asking, an informant is acting at the request of the government, right, and engages in what would be an unreasonable search or seizure, I mean, we ascribe that to the government. So someone who is acting under this vigilante law in Texas, under the authority of this Texas law, isn't there an agency here, or is that too far afield? Anyone?
I think that the Texas, it's so specific in that it bars enforcement by state officials that I think they've really created a disconnect there that I would not want to try and litigate, at least in the Fifth Circuit. The other thought, go ahead. Sorry.
Yeah, I mean, even though whoever does bring a cause of action that's authorized by this law is acting under the authority of this law, I mean, there wouldn't be a cause of action otherwise, right? I mean, this is created by the government, right? The government is extending its own authority to individuals to bring this. So they can claim that they're not enforcing it, but they've certainly enacted legislation to authorize this. They've deputized these individuals. They can call it whatever they want, right?
Well, I mean, to be the devil's advocate for
Yeah.
the law, although it just shows how distorted this law is, I think the theory is it's almost more like a tort action. The government has created the tort
Yeah.
of improper abortion and has made everybody a plaintiff. So when the government, we could imagine, I don't know, maybe a tort of unlawful eviction because obviously there's a lot of debate in the legislature now about evictions. And instead of having a housing agency enforce the law that says you can't evict somebody if they're only 2 months behind on their rent or they've been sick, whatever, basically says it's a tort for the landlord to try and do that, and the tenant can sue for triple damages.
Yep.
That's what they're doing. Only instead of narrowing the class of potential plaintiffs somehow to, I don't know, let's say a family member of the woman seeking abortion, it's universal. And I mean, I do wonder whether under, I mean, it's not going to happen in Texas, but whether under state due process doctrines, you could have something, you could have some challenge to some of the other features of the law, such as the universal plaintiff status, or basically the lack of any standing requirement, or the extremely one-sided procedural rules about, one side can get attorney's fees and costs, the other side cannot. One side can pick venue, the other side cannot. I mean, it's incredibly asymmetrical in a way that favors plaintiffs over defendants in a way that one doesn't ordinarily see in civil litigation. Now, I wouldn't, just the way Justin said he'd be laughed at Louisiana courts, I'd be skeptical about how far this would go as a matter of Texas state due process, but it does strike me that there is a due process problem here, and the pre-enforcement judicial action, which is really a product of federal sovereign immunity doctrines, should not, well, I don't know if they would apply in the states, which are in the law of the state, but it does.
Let me just jump in here, because there actually is there's a Texas case challenging SB8 on state due process grounds, which one of the interesting things about the case is that SB8's drafters forgot to account for the Texas multi-district litigation statute. And so although SB8 plaintiffs generally have their choice of venue, the cases can still be MDL'd. So all of the SB8 related cases that were pending in Texas were consolidated before Judge Peoples in Austin pursuant to the Texas MDL statute. And the judge actually found that several aspects of SB8 violate due process. There was one feature he latched onto was what he characterized as the punitive damages provision, because there was no relationship between the statutory damages that are available under the statute and the injury that a party is required to demonstrate. But another feature of his another feature of the statute that he latched onto in finding it unconstitutional as a matter of Texas law was the complete delegation of the state's law enforcement capacity to, as the statute describes it, any person. So the judge also denied an anti-SLAPP motion, and so that the entire case has gone up to the Intermediate Appellate Court in Texas, which interestingly has been there's been a fully briefed appeal for several months now that the Intermediate Appellate Court hasn't ruled on. But there is this, this due process challenge it's working its way through Texas.
David, the other thing that that your remark makes me wonder is, most states have adopted some version of the Uniform Enforcement of Foreign Judgments Act. And the UEFJA usually has a provision in it about dishonoring foreign judgments that are obtained unconstitutionally in the original jurisdiction. And so, not to throw the people who live in Texas wholesale under the bus and say, all right, well, you guys are on your own. Other courts in other states, when it comes time to execute on those judgments, because a big target of SB8 is abortion providers in other jurisdictions, I think we're going to start seeing how courts in other states treat those judgments as garbage and say, well, sorry, you can't have what you're looking for, Mr. Texas plaintiff, because your judgment is no good in New York or California or Washington State or whatever.
And would that be because of New York or the other states' state constitutional due process, or because they would view it as against their own state public policy?
Any number of reasons. But I mean, what it would come down to is the local court, like the New York court, saying, well, this judgment was obtained unconstitutionally in the state of Texas, in our opinion. And so we're not going to honor it, whether it's for due process reasons or public policy reasons, or because Dobbs hasn't hit the fan yet and, abortion is still technically a constitutional right. But yeah, there might be avenues there for other states to foreclose collection on these judgments, making them essentially worth, still valid in Texas, but not worth the paper they're printed on anywhere else.
Hey, Judge Stein, get on the phone with your former colleagues. Yeah, and let them know.
I don't have a voice there anymore, sorry.
Patrick Woods, you've had your hand up.
I think this is a good time for those of you who are here for the CLE credit to get the code word that you're going to need to put on your form to get the credit. The word is bounty, B-O-U-N-T-Y, bounty.
Like the paper towels, right?
Yes, like the paper towels.
And that's it. All right. Let me ask this: how would the Supreme Court 5 years ago, have dealt with this? What would they have done? David, you apparently think that's an hysterical question, so go ahead.
I'm not a particularly good criminologist when it comes to the Supreme Court, but I think this is one of many ways in which the swing justice switching from Chief Justice Roberts to Justice Kavanaugh has made a difference. In Whole Women's Health and in other cases, you see him attempting to forge positions that, among other things, preserve the Supreme Court's position as the ultimate arbiter of federal law and ensure that there are effective mechanisms through which the Supreme Court can exercise its law declaration power. And in Whole Women's Health, that obviously, that effort obviously didn't succeed. If it were a different court, I think he might have had some more success.
And do we think that the results in the Whole Women's Health case and future cases would be different if they were not, if these vigilante statutes were not dealing with something such as the right to choose? If they were dealing with something else, would the court be more amenable to throwing out these statutes? Anyone?
So I think that's something we're going to see pretty soon.
I mean, or is the issue with this Texas statute, is the issue, that is the way in which the current court ruled on it recently, is that because it had to do with the right to choose, which is so detested by a majority of the court?
So the Whole Women's Health litigation was incredibly compressed in terms of its time frame, right? The court initially tried to just get rid of the case by denying emergency relief, and then there was really sort of a backlash against what appeared to be its willingness to gut Roe through a very thinly reasoned order entered on its emergency docket. But even when the appeal or that led to Justice Gorsuch's opinion went up, the court decided that on an extremely rushed timeframe. One thing that was squarely in front of the court, though, was the fact that this scheme could be exported to other domains. And for folks who are interested in the filings, I really recommend a brief filed by a group called the Firearms Policy Coalition, which was written by a former law clerk to Justice Thomas, which spelled out really in striking detail how the SB.8 scheme could be used to regulate firearms in a manner that the court deemed inconsistent with the Second Amendment. It just fell completely on deaf ears. There was absolutely no interest in pursuing the arguments that were advanced in that brief. As Justin says, I think it's likely that over the next year or two, a legislature in a left-leaning state will enact a law that incorporates some aspects of SB.8's enforcement machinery to advance progressive priorities. There might be an effort to take that to the court to see if the court really meant what it said about the unavailability of pre-enforcement review. But even then, I think it's important to point out that the blue state laws aren't really going to be simply the mirror image of what Texas has done in SB8. There's a guy at Duke named Jake Charles, who's about to become a law professor at Pepperdine, I think, who wrote a really nice article comparing and contrasting SB8 with proposed legislation in California that uses the SB8 enforcement mechanism to go after gun dealers that facilitate the sale of guns. And as he points out, the California legislation doesn't infringe anything or doesn't infringe any Second Amendment right that's been recognized in the Ninth Circuit. So there's kind of an attempt to use private enforcement to insulate state policy from the court's constitutional judgments. But it's nowhere near as extreme as saying, here's this established right, and we are going to thumb our noses at it by turning it into a private right of action that's inconsistent with the court's precedents.
So is the possible infirmity with these laws because in Texas it's about what at least still is a constitutional right? Or is it actually, is there an infirmity because of the vigilantism?
I think there's some overlap there. Guns have their own amendment, and political speech, online speech. I'm sure y'all have been following Texas HB 20, which went into effect yesterday. That's the law that allows the state of Texas to require social media companies to police their own content. The Fifth Circuit let that one slide, despite its obvious First Amendment problems, I think, and federal preemption problems as well, given Section 230 of the Communications Decency Act. That's another bounty law. It's not as strict as SB8. But you can see that the state felt like it had a working model, and so it decided to go with it again. But online speech also has its own amendment. So maybe there are some protections there that the court is willing to afford, these rights that are more explicitly protected by the Constitution, as opposed to, the court's current feelings on abortion.
But suppose you had a bounty law that was not targeted towards those who were sought to exercise a constitutional right or aid those, but for something entirely different, such as a bounty law modeled just like Texas's, except that there was a cause of action for those, and they would be entitled to at least $10,000 if they sued police who they saw engaged in unreasonable searches and seizures, or invalid, some compulsory interrogation. And you did the exact same thing, and they sued the police. That gets around any of the state law, the federal laws about qualified immunity, but it puts people in the armchair of perhaps being authorized to bring causes of action. Anyone? I mean, is that okay? Is that going to be okay because we want to enforce the laws against unreasonable searches and seizures and compulsory interrogations against police? And in that instance, the bounty law would be fine. So then it's really not a bounty law that we don't like. I mean, I don't know. I'm asking it because I really don't know. Richard, come on, help me out.
It just strikes me you're not going to see that law passed. I don't know. I mean, we'll see. I mean, the question, I mean, we're sort of in this gray area between what would be constitutional and what would be wise, I suppose. And does a law like that make sense, especially given in that setting, you're talking about there are actual victims of the misconduct who have their own incentive to resist it in their own cases. The question is, going beyond, say, the person who's the subject of an unlawful search and seizure, being able to sue versus somebody who witnesses. I mean, basically what you're doing, what all these things are doing are rather dramatic extensions of the law of intentional or unintentional infliction of emotional distress. What we've really got here is some massive potential for expansion of a tort. And beyond any traditional notions in our system of who has standing or who is a victim of somebody else's misconduct. And I think it's really, it's at that level. I mean, that's what's so dramatic about the Texas law, about SB8 itself, is that anybody can sue, literally anybody. Whereas some of the other things you're talking about, you don't have to witness the abortion. You don't have to be in the same county as the abortion. You just have to be aware that it happened. So, I mean, I don't know, it strikes me as this is such at the far range of the kind of, I'm mostly sort of focusing on who the plaintiffs are. I mean, there's the other things here too, in terms of the sheer imbalance in the law in favoring the plaintiffs, but the fact that it's basically a law of universal plaintiffs, which I think probably makes it different from almost any universal plaintiffs, but not the government. The government has traditionally been the universal plaintiff in the sense that if we can consider that there's a violation of some norm, some civil norm, a norm of civil behavior. But we're basically making is that where everybody is now going to be policing everybody else, except for the police themselves won't be doing the policing. And that's, I think, what makes it so striking. Now, why the Supreme Court, to get inside the criminology of the Supreme Court, and would they have done it differently if it had come up as a firearms law? Who knows? And maybe they're hoping this law will, in effect, go away with Dobbs. Nobody will be doing abortions in Texas pretty soon, so you won't even need this law. But the template is there, and the question is, well, who's going to use it next and for what purpose? And will it be as dramatically detached from any reasonable plaintiff? Even Vincent, even your example is not very detached. Somebody who's witnessing misconduct could be traumatized by it. But this in effect is saying that you're traumatized by hearing that this thing occurred, not witnessing, not being not being personally involved in any way, but just hearing that you happen to be a resident of the same state and you heard about it, and that's enough to have caused you injury. It's hard to. That's why I think is maybe one of the many striking features about this law.
Right. And of course, the fact that it is about abortion rights, I mean, especially, well, not that we really needed Alito's draft opinion to know that, but the emotional hatred, the religious hatred for abortion rights by several members of the Supreme Court, it's hard to imagine that didn't affect how it is that they voted and how Gorsuch wrote in the whole women's health case. So I'm not so sure that the court would have ruled the same way if it was a different bounty statute, right? So, but still, with regard to the whole standing, with regard to ripeness, with regard to personal injury, with regard to judicial review, can any state be that successful in precluding judicial review? I mean, or do the states, do the courts stand up and say, no, you can't do this. You just can't preclude our review. Justin?
Well, I was just going to add a very sort of on the ground practical litigators.
Yeah.
Judges hate being told that they're not allowed to do something.
Right.
It's the truth. I mean, it's something that every junior associate, who walks into a courtroom for the first or second or third time learns. Oh, Your Honor, you don't have the authority to do that. Well, oh yeah, watch me. That's not 9 times out of 10, but oftentimes that's the reaction that you'll get. And so if these laws gain popularity, you're going to get a lot of judges, including appellate judges and justices of the Supreme Court, who are tired of the states taking away their constitutional authority that's been around for 250 years to assess the constitutionality of state laws. And what will they do about it? I don't know. But they will find a way to preserve their jurisdiction.
Remember also, the first time that somebody brings a civil action to enforce the law, the courts can review it and throw it out at that point. I mean, this is really about, well, the lawsuits are about people, groups like Planned Parenthood or Women's Health of the United States coming in and saying, we want the whole thing knocked off the book, declared unconstitutional. But the first time that a plaintiff could come to court and say, gee, I heard about an abortion on the other side of the state. And I just brought a lawsuit and I want my $10,000. It's at that point, a trial judge can say, oh no, yes, you've got this statute, but it's unconstitutional for the following 8 reasons. So it's, being devil's advocate and taking Justice Gorsuch's position just a little bit, leaving aside the interim effect of this law being on the books. But the moment somebody actually goes in and tries to collect that bounty, that's when it's possible that you might get a trial judge or an appellate panel saying, oh, no, you can't.
Well, that, of course, would be the point at which there would be no question about rightness, right? There would be no question about personal injury for standing, right?
Or there would be a question, that might be a basis for throwing it out.
Yeah, yes, right.
But there would be no question about pre-enforcement. They'd be enforcing it. At that point, at the very least, we're in Shelley versus Kramer, if not everything else.
Yeah. So is Shelley versus Kramer, is that by and large by the wayside with this current court?
Well, I think they would say, again, borrowing the Justice Gorsuch hat from Richard, I think Justice Gorsuch would say that Shelley is a case about 14th Amendment state action. It arose in a defensive posture. If there's an SB.8 judgment where the law's constitutionality is at issue, the Texas courts are required by the Supremacy Clause to resolve the federal constitutional issue, and that can go up to the U.S. Supreme Court on an ordinary writ of certiorari. What the Supreme Court is declining to do in Whole Women's Health, sort of as I see it, is sort of grapple with the reality of what Texas did through SB.8 in its pre-enforcement justiciability jurisprudence. And it is, my reading of the case is that the court doesn't want to take seriously the possibility that a state, through creating a private right of action with associated procedural manipulations, can effectively stop a category of business activity that enjoys constitutional protection. And sort of the whole move of the Whole Women's Health opinion is to say, no, this is an ordinary tort suit. You can raise constitutional defenses in response to an ordinary tort suit. And the court never really grapples with the reality of what Texas has done in SB.8. And just sort of getting back to, whether this is a good for one train only ticket, am I messing up the phrase, right? But, I have a hard time, and to your point, Vince, I have a hard time imagining a state effort to completely nullify a constitutional precedent outside of the abortion context. Maybe some of this anti-CRT stuff will create similar tensions with respect to speech in classrooms. But it does in part come out of the fact that we have a decades-long movement to overturn Roe. There are fissures within the anti-abortion movement about how best to pursue the strategy of rolling back abortion access that you see manifested in SB.8.
Yeah, well, of course, beyond abortion rights, separation of church and state. I can imagine something similar with regard to challenging those who might take actions that are deemed to be, you know, trying to separate the church from the state. I mean, the same, if you look at the majority of the court now, I mean, perhaps other than the Chief Justice, it doesn't seem like they care that much about the non-establishment jurisprudence at all. I mean, they always come up with some excuse for allowing, you know, state endorsement, state promotion of religion. So I can imagine something like that. But let me ask you this: suppose Chief Justice Roberts is able to drag at least one of the other more conservative justices over to his side. And so what happens in the Dobbs case is simply to say that, okay, 15 weeks is okay, but we're not overruling Roe versus Wade. And then this case comes back, this whole women's health case comes back. Then does the majority do something else with it? Pre-enforcement?
So I feel like I have to point out that whole women's health, the case that we've all read, is dead now, thanks to the Texas Supreme Court's decision that members of the state licensing board don't have the authority to enforce the law. But if the constitutionality of SB8 came up before the Supreme Court, I think that's going to be on a writ of certiorari from a Texas judgment of some sort. The court has, you know, very clearly expressed its preference that it doesn't want to sanction a pre-enforcement Section 1983 challenge to the law. And so there's the case in front of Judge Peoples that's in the Texas courts. There's the possibility of other offensive litigation coming up through the Texas courts. One of these cases against Dr. Baird could come up to the Supreme Court. And then you have, you know, sort of a more traditional constitutional challenge where it's the defendant in an SB8 action making the argument that the law is inconsistent with the court's abortion jurisprudence, and that, you know, that's just a question of where the substantive law is at.
And so there might be, I mean, even though Texas and the Texas Supreme Court have made this even less of a government action, even less of state action, if there still is a right to choose, perhaps this current court, led by the Chief Justice, might throw out a bounty statute, the same bounty statute.
Well,
Sure. Go ahead.
Go ahead, David. Go ahead.
Oh, I was going to say, if it comes up in a defensive posture, sure, it's a possibility. But then you're simply, you know, what's coming before the court is the law's substantive provisions. You know, particularly if the Texas litigation stays within its current frame of whether SB8's enforcement provisions are consistent with Texas due process, then that's not something that would go up to the U.S. Supreme Court, because that's a question of Texas law. Right.
But even pre-enforcement, do you think the ruling of the court would be different with regard to pre-enforcement, or would they require someone who's actually been sued?
I think that the ground is going to shift to legislative responses. I think there's going to be state legislative responses to these kinds of laws that are adopted by left-leaning states. The court in whole women's health sort of essentially invites Congress to create a more expansive statutory cause of action through which these kinds of schemes can be challenged. And so I think, sort of thinking about the future of these laws, I think what's happening in state legislatures and potentially in Congress is going to be a lot more important. I mean, sort of, I understand everyone's sort of looking for the way to thread the needle of the court's justiciability jurisprudence. And as a federal courts guy, I enjoy, you know, thinking that through as well. But events on the ground are moving so fast, and there's going to be state legislative responses. I just wanted to highlight that there's a wonderful article forthcoming in Columbia Law Review called "The New Abortion Battleground" that tries to unpack some of the interstate conflicts of law that are suddenly going to happen, assuming that Dobbs comes down the way we all think it will, which is, the article, tries to give you a tenth of the interstate conflicts of law that are going to arise. And I think the treatment of judgments under SB8 style laws, and we've barely even talked about counterstrikes, and the way that, say indemnity obligations or clawback rights might work if New York were to adopt such a statute, that is all going to become hugely important.
Well, this has been absolutely fascinating. I've learned so much. I think we all have. So thank you so much. And thank you, Government Law Center, for inviting me.
It's been terrific. Thank you, Professor Bonventre, and to all of our panelists. Really, stay tuned, I guess, is really all we can say, right?
Yeah.
But you've all added a tremendously interesting perspective. Thank you.
Thank you.
Thank you very much. Thank you
That's
for the
great.
invitation.
That was terrific.
Yeah,
These guys
thank
were
you
great.
all.
These guys were great. Oh, they're still here. Yeah.
Are people sticking around for a few minutes? I've got a few minutes. I don't know if there are questions.
Happy to chat if anyone wants to follow up on anything.
Yeah, there were no questions submitted to me in the chat. I had several of my own ready to go, but
I mean, yeah, this was hugely informative for me too. I hadn't. I'm a First Amendment guy at the NYCLU, and Chris Dunn forwarded this request to participate to me because I'm up here in Albany. I work out of our Albany office, so it's easy for me as a representative of the NYCLU to handle anything that arises upstate. And so, of course, I was more than happy to do it. But like, this isn't my area of law. So, I mean, and then David, I read that Duke piece a couple of days ago. I thought that was fascinating. But yeah, I mean, I'm genuinely curious to watch this whole process unfold and see what states do with their own retaliatory laws. New York is already floating dozens of bills to defend itself and to defend healthcare providers and abortion providers against enforcement of laws like this, barring interstate cooperation with subpoenas and discovery and with medical licensing, requests, and with insurance obligations, malpractice insurance and things like that. So, I mean, it's gonna tangle its way into so many areas of law, and it's just gonna be insane to watch it unfold.
Mm-hmm.
Well, I read sort of relatedly an editorial this morning in the local paper, which was a reprint from the St. Louis Post-Dispatch, and I don't know if you've seen it, but the title is "Up Next: Defiance of the Supreme Court," and and that is whether state legislatures are going to just do their own thing.
Yeah. And it may have sounded a little silly when I mentioned it, but I was serious when I said that federal judges don't like to be told that they don't have the authority to do something.
No judges like to be told.
No.
Unless they don't want anything to do with the issue.
Sure. But I mean, I've been in front of more than a few judges, and you get that one eyebrow that goes up when you say, Your Honor, I'm not sure you can do that, and you slowly back away from the podium. But it's, it's the truth. They get to decide. They may decide the law is constitutional. They may decide it's unconstitutional, but the decision is theirs. And when you take that decision away, if you do it enough times, they're going to come up with a remedy. So, purely from a litigation standpoint, it'll be funny to see what happens there.
Yes, it will. Well, we'll have to do a reprise of this.
Absolutely.
At the appropriate time.
Yeah.
It is interesting. Idaho, I think it's Idaho that I'm thinking of, did a version of SB8, and the state Supreme Court has some kind of extraordinary writ procedure where they, they sort of act as a council of review, and they can take up legislation and look at its constitutionality before the law is applied. And the state Supreme Court stayed enforcement of the law using that procedure.
Yeah, I had been wondering if state courts that have advisory opinion power
Right.
might be a way to backdoor federal judicial review eventually, if they use it that way to say this is unconstitutional, potentially allowing it to go to the Supreme Court.
Right. I mean, I'm sort of surprised that the Texas Supreme Court has been, at least in the certified question that it received, has been still willing to go along with SB8, because, I think that Supreme Court has, it has a conservative identity, but it's not completely aligned with the conservative political movement. And I think some of the Texas Supreme Court's decisions reflect a desire to stay out of hot button political issues. And so it's been interesting to watch as the court has allowed SB8 to operate.
Right, but that's another court that has changed quite a bit over the last several years. It does seem to me it has been moving rightward for the last couple of years.
Yeah, there's certainly some MAGA style justices or just judges on the court, but there's also institutionalists.
Do you all mind if I float one question that I've had bothering me for a while?
Go ahead.
I am curious what you think about how effective states that might want to co-opt the SB8 type mechanism could be using it to do things like trying to get ahead of where federal regulations are in areas where there's preemption. And I'm thinking of things like automobile carbon emissions, or fuel efficiency standards, or federally preempting the laws limiting, requiring energy efficiency of household appliances, all of which are preempted federally, set federal standards unless there's something that's carved out in the federal statute. But I could certainly see a state law that does a bounty type thing that says, you can sue any auto dealership that sells a car that's less than a certain fuel efficiency. And I wonder if the mechanism would be enough to move the market before it got judicial review.
I'm not sure about that at all, but what's pretty clear from this court's, the current Supreme Court's preemption case law, there may be all kinds of principles and guidelines and doctrines and everything, but as I tell my students, look at what's at issue. I mean, look at what's at issue. If it happens to be one of these things, it's has to do with regulation of business. It's something that's being challenged that otherwise would be business friendly. The conservative justices vote the other way. So state wants to regulate the environment more than the federal government. You're going to have the conservative justices saying, no, you can't do that. Immigration, the same thing. You get the conservative justices say, yes, the states can regulate it more strictly. So I think you have to look, what exactly is at issue? What is really at issue? So grab people off the street corner that pay attention to politics and say, what do you think about this? And how do you think the conservatives are going to vote? How do you think the liberals? And they probably have a much better idea about that, more realistic than a lot of law professors do.
I still have no audience questions in the chat for those who are left. I really appreciate all of you taking the time to do this today. I think it was a really good discussion. And I saw a number of staffers from the state legislature in among the audience. So
Okay.
Yeah, good. Well, David, Richard, and Justin, thank you so much. It was really great to be with you. And of course, Judge and Patrick, always great. And a lot of you in the audience too. I see Richard Rifkin's in the audience. How great. Yeah. Barbara Jordan's in the audience. Boy, a lot of great people. Yeah.
Take care.
Bye.
Yes, take care,
Thank you
everyone.
all.
Yeah.
Thank you again.
very much, everybody.
Bye-bye.
You get great audiences, don't you?
Yeah,
Yeah.
oh, yeah.
They're really fantastic. I
They
was looking at
are.
all these names. Wow, it was great.
Yeah, we have a lot of repeat attendees, and then we always get some new ones as well. So it's serving a beneficial purpose.
Yeah, well, great. Well, thank you so much for inviting me.
Thank you
was
for
really-
doing it.
it was
I-
really
Yeah.
terrific.
Yeah, we really appreciate it. It was excellent. Thank you.
Thank you all very much. And feel free to invite anybody from the NYCLU back. I'm available for all kinds of stuff, and
Cool.
I'm right down the road.
Cool.
That's great. Thank you. Yeah,
Yeah.
that's really terrific.
All right. Take care, everybody. Have a great rest of the week.
You
You
too.
too.
Good luck with the rest of the session if anybody's dealing with that.
I've only been tangentially involved because when they raised the state constitutional minimum for New York City Civil Court, they didn't fix the statutes that also set the minimum. So two other professors, Professor Hutter and Connors, have been chatting with them, and they're trying to get them to do something over there to avoid that becoming a big problem when people with $27,000 lawsuits bring them in the wrong court.
Oof. Yeah. One of the things on my docket over there is short-term or sort of last-minute opposition to unconstitutional bills that get floated. And so, I mean, for the next couple of weeks, I'm just going to have stuff coming over the transom, stuff that violates some federal law, or, something that's just a First Amendment problem, or just a bad idea, a raft of unintended consequences waiting to happen. June 2nd can't come soon enough.
It's good to know that you at least get the opportunity to do that.
Yeah.
We have instituted at Patrick's initiation a new program, or we're just in the process of launching, hopefully soon, a program where we go through state court decisions, particularly the 4 appellate divisions and the Court of Appeals, and for cases in which they're interpreting statutes or regulations as either, we think the legislature meant this, or this is unconstitutional, or something of that nature. And then we're putting together a very short little summary and a blurb and sending it on to the appropriate people in the legislative and executive branches, so that they know it, that they know it's happening, and they can say, no, this isn't what we meant, or oops, we goofed here, and we need to redo this.
Well, Judge, if you want to add New York's recently amended anti-SLAPP law to that book of recommendations, along with Rich Ankowitz and somebody from Senator Hoylman's office, a guy named Burton Phillips, I helped draft those amendments a couple of years ago. And we're seeing now that the courts are not giving the phrase matter of public concern a broad enough interpretation to find that something would fall within something that would meet the criteria of a defamation action eligible for anti-SLAPP treatment.
Interesting.
So if I could just throw a little pitch in there for that.
We'll keep an eye out. Yeah.
If you see any decisions that look like they've construed the anti-SLAPP law too narrowly when it comes to what is a public matter and therefore, worthy of anti-SLAPP treatment versus what the statute calls a purely private matter,
Right.
then that's something we would be interested in.
So if you have a list of such decisions, send them
I-
on to us.
Yeah,
Sure, I can reach out and forward them to you because we've been tracking them. So yeah,
yeah, definitely send them to me.
yeah.
Yeah,
Well, I'm glad I brought that up then. Thank you. Thank you very much.
there you go. Okay,
All right. Take care,
Be well.
everybody.
be well.
Bye-bye.
Vin,
Bye.
before you
Yes,
run.
yes, I wanted to talk about, so.
Okay.
Okay, do you
Are we
want me
still
to?
recording?
Oh, yeah,
Uh,
yeah, you are.
yeah.